Hey everybody, how's it going? This is Seth, Keeping It Real. Today I am very privileged to have a special guest here with us. Her name is Suzi Hixon, and she is known as and becoming known as the private label lawyer. If you just type in the private label lawyer and you Google it, you're going to find Suzi Hixon, and she's becoming better and better and better known. And as a result of that, there's a lot of people who are selling on Amazon who have received help from Suzi at all sorts of different levels, but specifically for trademarking. Now, as you guys know, I lead a team of over 200, about 240 people now who are selling in Amazon. And I and 8 other coaches are coaching them to help them to succeed. And our whole goal is to show them how to build passive income by doing what we call private label. And so today we're going to talk about, what is private label? Why is the importance of protecting your brand become so increasingly important today? And what are the most common questions? One of the things I keep hearing these days, Suzi, is constant questions about trademark. Is it important? Should I get my brand trademarked? And I'm just going to ask the most basic question of all. Should people trademark their brand, and why? If I can just jump right in.
Yeah, let's get started. Thank you so much for having me, Seth. I really appreciate it. It's fun to be here, and it's going to be really cool answering people's questions live on YouTube. But to answer your question, should people get a trademark, and why should they? If you're private labeling, one of the inherent parts of private labeling is labeling. And how do you do that? You are basically importing or maybe purchasing product that's manufactured here in the US, and you are labeling it as your own. You're branding it. And a trademark is just a subset of a brand. A lot of people ask me, what is the difference between a brand and a trademark? Your brand is your overall look and feel. It's sort of this umbrella that can encompass a lot of different aspects of your business. It could include sort of your look and feel of your website, the colors that you use, the way that you use your language. Do you have a fun brand? Is your language whimsical, or is it more serious? And then your trademark is just, like I said, a subset of your entire branding. And your trademark is typically, word or words that help people identify the source of your product. So, and that would be different than something being generic. And the way people identify the source is by the different trademarks that are out there. So when you go shopping for shoes, you know whether or not you like Nike or New Balance or Solomon. We all have our tennis shoes that we love, or the apparel that we love. Those are all trademarks, and that's how we tell the difference between a Nike pair of shoes and a New Balance pair of shoes. And that's basically what you're doing with private labeling. You are developing your own trademark and assigning that trademark to your products, and that's how people in the marketplace will distinguish your products from those of others. That's how they'll distinguish your garlic press versus someone else's garlic press. Sorry.
I love how you mentioned.
I think I'm kind of probably going to pour that one out.
No, I love how you mentioned garlic press, because there's certain trending buzzwords at Amazon, and that's become one of them. You hear about it a lot. So I love how you mentioned that. There's garlic presses. There's the fidget spinners right now. The foam rollers. Like, there's all these ones that people use as examples, and it just cracks me up. So,
right.
I jumped so quickly into a question. Can you introduce yourself a little bit? Like, where are you from? How did you become a lawyer? And why Amazon? What's so unique? And this is what really got my attention, because Melissa on our team, she recommended you. And so that's how I heard about you. And what was so unique is there's a lot of lawyers out there. And some people assume if someone's a lawyer, they're just going to know the answer. But then there's actually lawyers in different categories. There's all these different specific categories. And to have one specifically focused on Amazon, and I heard you actually are a seller on Amazon as well, which I think is really cool. So how did you end up starting as a lawyer and then becoming one that focuses on Amazon stuff, which I find really fascinating?
Oh, wow. Okay. Well, I graduated from law school in 2003, so I've been practicing for a little while. And I started out doing patent work because I had a science background. And so that kind of enabled me to get into patent law. And I did that for about a year and a half. And in the patent world, you know, you're working with a lot of people who are inventors, a lot of engineers. I didn't love that area of the law. And like you said, there are so many different areas of the law. You know, there's family attorneys and people who do personal injury and insurance. Like there's so many different kinds, but I just kind of happened to end up in the world of intellectual property. And intellectual property includes patents and trademarks and copyrights. And so after practicing patent law for about a year and a half, I kind of decided that it wasn't the best fit for me, and I evolved over to trademark work, and I loved it. And I've been doing that specifically since 2005. And I've been working, I worked at a couple of larger firms, and I've been solo for several years. And there were several reasons for going solo. One is that I just knew that big law firms have so much overhead, and I could provide really the same service at a lower price to smaller companies. And that's who I preferred to work with. I love working with small businesses and startups and individuals. A few years ago, I had a client who was selling on Amazon, and I was like, what is this? Like, what is he doing? And I started looking into it a little more. I've been a consumer on Amazon for a long time. I actually sold law school books years ago when I first graduated from law school because I was so broke. I sold my law school books on Amazon, and that was, you know, in the early stages. And a couple years ago, like I said, I had a client that was selling on Amazon. I wanted to learn more about the platform from a seller perspective, just to kind of understand more what he was doing. And I actually did some private labeling myself. And the first product I imported and put on Amazon was around the holidays, and it just took off. And so I was so excited. I was like, I am a genius at this. Like, this is fantastic. But then I realized that everything is selling in December. You know what I mean? Like, people are desperate to buy Christmas presents for people.
Goes like that.
Yeah, so I could have been selling anything, and I think it would have sold. So I was feeling pretty cocky about that, and so I did another product that spring, and it was a complete failure. And that's okay. And I still have a bunch of the products sitting here in my office. I need to figure out what to do with it. But that's, you know, I feel like when you do this, you learn a lot by every step that you take. And it really is a learning process. And that's, you know, I really feel like I learned a ton from that. And just by hanging out on Facebook groups, in particular, I realized, like, there's a huge need for people or for someone who kind of knows the back end of Amazon, and someone who knows about branding and trademarks, you know, and how to enforce trademarks, because that's what I was seeing a lot. There were a lot of problems with people trying to figure out how to pick out a strong trademark and how to enforce their rights on the platform. And so even though I'm really doing the same type of law that I've been doing for 10 years, I just kind of rebranded myself as the private label lawyer. And I have a registered trademark for that. Woo-hoo. That's how I got into working with Amazon sellers.
So I got a question. It's a completely personal question for me. Keeping it real is, I told you, it's sort of like it just, you know, that phrase. Yeah, it's a phrase off my last name. It's about keeping it real, because I love keeping it real. Here's how it started. I have never shared this on YouTube before. So I was at Apple. I was a manager for a tech support team. This is long before I fired my boss, started my own company. And there was this guy there. He is a professional singer in Austin, and he was on my team. And, you know, whenever we'd have coaching sessions, I'm pretty, you know, expressive and passionate. And so one day he's like, it's Seth keeping it real. And this way later, like a year later, I'm doing a video, and suddenly just hit me. And I was like, I should say that. So my question for you is, should I trademark that? Or is it so, you know, the last name is really weird. It's Kniep. Or is it unique enough where I shouldn't worry about it? Like, what are your thoughts? Should I trademark that phrase? It's a sincere question, but I'm just curious.
Well, it depends a lot on how you're intending to use the trademark.
Right.
If you're going to want to use it sort of in association with consulting services, then you may want to consider filing it as sort of a logo or I guess more as a tagline. Right. And there would be a few things that we would need to consider before you filed. And really the primary issue would be, is anyone else using it for something similar? Keeping it real? Probably not. You're probably good to go in terms of a likelihood of confusion situation. You probably wouldn't run into that type of obstacle if you did file a trademark application for it. So my advice for you would be to definitely consider filing it. If you're a little bit on the fence about it, if you're not completely like sold or attached to it, or if you think you might want to wait and see if you have funds rolling in that are associated with the use of the mark, you could put it off a little bit. In the meantime, I would suggest that you use the little TM next to it.
You have trademark,
little TM, yeah. And a lot of people think that you have to have a pending application to get to use that little TM, but you don't have to.
Yeah. And you know how I know that is because I watched another interview from you.
That's important. Yeah, and I bring that up a lot because it's a common question that I get, and I feel like there's a lot of misinformation out there about that. I do scan some of the Facebook groups still, and I do come across that that misconception that you have to have a pending application to get to use the TM, but that's not true. So you can go ahead and start doing it.
What is the difference then, and this is from Jacob Baghdadi, between a trademark and a service mark?
Hey, Jacob. Yeah, that's a great question. So they're basically the same thing. They are basically the same thing. A trademark would be a mark that's used in association with goods. Are you selling tennis shoes? Are you selling fidget spinners? Are you the new garlic press? Are you selling garlic presses? Trademark. That would be associated with a good. Now, a service mark is really just a subset of a trademark. It's still just a source indicator. It's a great question, Jacob, and it does deserve clarification. But the service mark would be associated with the offering of services. So let's say I'm a consultant or I'm an attorney. I'm looking over here at I'm going to show. I don't know if people can actually see this. This is my registration certificate.
Yeah, we can see it.
And this is what you would get once you get your trademark registered. Obviously, it's a lot more valuable than this piece of paper. This was like kind of all been up. But here it says International Class 45, and it's for legal services. So with the USPTO, you have 45 different classes of goods and services. And legal services would fall into International Class 45. Toys are product or are goods, and they're going to fall into Class 28. If you sell pillows, they would fall into Class 20. And so if you go to USPTO.gov, you're going to see you'll be able to look up all the different goods and services.
Right.
And if you file a trademark for a good, pillows, garlic presses, fidget spinners, that would be considered, a product for goods, and then, or a trademark for goods. And then if you filed, for your consulting services or legal services, that would be considered a service mark. So, Jacob, this is my trademark here is the private label lawyer. It's a trademark, but it's kind of, I'm offering a service with, in association with this trademark, and so it's basically a service mark.
Got it. That makes total sense.
Yeah, and so you would still, once you get the registration, you would use the R in the circle, and that's reserved only for registered trademarks.
Right at the end, yeah. Yeah, that's really good, because I used to think if someone says TM, they're saying they have the trademark. So TM is saying, hey, everyone, back off. I have first common law, first right to use to this because I'm using it first. But then if I get the R with the circle, that means it is registered. It truly is owned by me legally.
Right. The TM just puts third parties on notice that you're claiming it as your trademark. If you offered a service, you could use the little SM next to your mark instead of TM. It doesn't matter if you use the TM instead of the SM. It's no big deal. Yeah. But it is a big deal using the R in the circle if you are not registered yet. So don't do that.
Okay.
Like that a lot. So
thank you.
I just really want an excuse to show off my registration.
I know. In fact, that's exactly. You had it there. He's like, wait, yes, I got it now. So we have a bunch of questions in here, which is awesome.
Okay.
So let's see. Joshua says, how do you, oh, this is great. How do you know if you are infringing on someone else's name or logo? Is there a way to find out? And I'm going to give an example. So let's say I'm on Amazon and I'm doing this for Dennis, because Dennis, I saw in the Q&A last night, you said I could do a raffle prize and guarantee which of the 3 products Seth will always pick up from his desk. Oh, I brought this for you, brother. It's a pipe. It's different. So let's say I want to sell a pipe and I have a name. And this, let's just call it Oakwood or something. How do I make sure that it's okay to use that as my private label, my logo, or my private label on Amazon, but make sure I'm not infringing on someone else? Do I go to USPTO and do a whole search? Do I, use CompuMark? Do I just search on Amazon? How do I know? Because there's so much out there, and then there's always this fear, what if I'd miss something? And then a month later, I'm sued for trying to sell this with the name Oakwood.
Yeah, it's a lot less expensive to be proactive and to do some searching on your own
So good.
versus this letter and having to go see an attorney at that point, or even having to deal with litigation, or having to deal with having to dispose of product or packaging because you have a trademark on it, and you find out later on that you're infringing. So who asked that question again?
Thank you. It's Josh.
Josh. Hey, Josh. Awesome question. I'm happy to answer that. So there, you have a couple of options. So let's say that you've picked a mark that you love and you start doing some searching. The first thing that you would do on your own would be a preliminary trademark search. And we also call them knockout searches. So, or quick and dirty searches. And you would use the USPTO website, and that's uspto.gov. I would suggest that when you're doing some searching, to do some spelling variations. So, for example, if your mark has the word male in it, search M-A-L-E, M-A-I-L. If it's something like checkmate, you might want to search M-A-T-E. You might want to search check M and the number 8. You might want to search it as one word. You might want to search it as 2 words. So as you can see, this can get pretty, this can get pretty in depth if you let it spend days searching. Another resource to consider using, of course, is Google. You can search KNOWEM, which is KNOWEM.com. And maybe I can have Seth put that website down at the bottom of the YouTube video at some point. That's a good one to search. And the good thing about that one, what I like about it is it helps you search domain names as well as social media handles and usernames. I think it's nice to be able to grab a handle that's consistent with your trademark. It's not imperative, but if you can grab the Twitter, Instagram, it's good. And it also, if you come across the Twitter handle and they're using your trademark, for example, you might want to dig a little deeper. Who are these people? What are they doing? So
right. What are they selling? What is their purpose? Because if they're representing fashion, but I'm selling pipes, there may be no conflict of interest.
There might not be, but there could still be. It just depends. Yeah. Another place I really think people need to search now is Amazon. Is someone else using the brand that you want to use already? Is it being used in a way that's overly descriptive? Because if it's descriptive, you probably won't be able to get a registration for it. You might not be able to get a registration for it. And we can get into that in a little bit. But those are some resources that you can use on your own. You can hire someone to do a preliminary search. I do preliminary searches for clients. And I'll spend a couple of hours looking through a lot of those exact same, platforms, but I'll give an opinion on, whether or not I think they should proceed with an application. There's also what's called a comprehensive trademark search. It's a very robust type of search. I do these for my clients, but I outsource the actual searching to a third party that has the software to be able to search the USPTO database, Dun & Bradstreet, state trademark databases, common law resources, and things like that. And you know how I was talking about, you should search variations of a mark, like checkmate should be searched in all these different ways. Well, using a third-party platform to do that type of searching for you is going to save you a lot of time in the long run, because it will search those variations, truncations of marks. You know, like when you do like a Boolean search and there's an asterisk used. So it can search a lot more variations than we can really do on our own. So I do suggest if a company is rolling out a new brand, to strongly consider doing a comprehensive trademark search. They're not cheap, but it's a lot less expensive than having to go back and rebrand your packaging or your product.
I really like how you said that. It's a lot less expensive to do the research now than to wait. I'm just thinking about, so there's some sellers here who are doing hundreds of thousands a month. If their brand is attached to that product and they get sued, if people were actually, because some of our sellers were finding they're now starting to search for their brand on Amazon, which is a huge compliment to them, like, wow, good job. But now if people are searching for the brand, but their brand's attached to the product, they get sued, like that's millions of dollars of inventory just gone to waste.
Yeah.
And here's something I remember when I started in this venture, I thought this, uspto.gov, you can't get more official than that. If I can't find it on there and I put in my application, I'm good to go. But tell me if this is correct thinking. If someone else was using that same name, we'll use Oakwood, for example, because I like this pipe. If they're using the same name to sell pipes like I am 10 years ago without a trademark, they might have a good backing to sue me, right? Because they were using it first. Even though I have the trademark, they were using it first. And USPTO is not going to have their information because they never registered. Is that correct thinking, Suzi?
That's correct. In the U.S., we recognize what's called common law rights to a trademark, and that's exactly what you're getting at. This makes a lot more sense back before we had the internet. So when you start developing common law rights, let's say that I open up a vegetarian restaurant in the middle of Kentucky, which is where I live. I don't think a vegetarian restaurant would really go over great here, but let's say it did.
You like barbecue, don't you?
Yeah, yeah, fried chicken.
That's like Austin.
Yeah, I'll take that. But if I did that, but I never filed a trademark application for it, my rights would only be limited to the geographic territory in which I'm using that trademark. Now with the fact that we have the internet now and we're able to sell products across the globe practically, that kind of throws that into question, and at some point it probably will be litigated about, where do your rights extend when it comes to, internet usage? Are we actually beyond the geographic scope of use? Internationally, it's first to file, but here in the US, we do recognize those common law rights. And so let's say you've been using your, you have your, your Oakwood pipe. Let's say that you started using it in 1995, that trademark. Yeah. But you didn't actually file the application until this year, 2017. Well, in that application, you would state that you've been using it since 1995. And only until you get that registration would you have presumptive rights to the trademark. So it's not like you would have to defend it. Now, common law use, you'd have to defend that use of it. Your trademark registration, you're actually given presumptive rights to the trademark as of the date that you first started using it, or the date that you filed it. And that's considered a constructive date of first use. And that's why in some situations it's wise to go ahead and file a trademark application with the USPTO, even if you haven't started using it yet. Yeah, you ultimately do have to show use of the trademark after you file it. It can be, the USPTO is very generous in the amount of time that they permit you to show your use, but you can file it on an intent to use basis. And I'd say I probably do about 50-50 use-based applications versus intent to use.
And that brings up a really cool question that a lot of people have been asking, and that is what are the advantages? Well, I guess this is a simple question, but the advantages of should I get my trademark internationally approved or just US? I'm guessing if it's international, I have protection everywhere. And is that more expensive? And I'm guessing I can't do that through USPTO because it's no longer US based. Like, what are the pros and cons of that?
Yeah, so trademark protection is jurisdictional. So if you did get a registration in the US with the USPTO, your rights only extend here in the US and I think Puerto Rico. Okay. Or maybe there is another, I don't know. I would actually have to check on that if there needs to be a separate filing in Puerto Rico, because that's kind of a weird situation. Now, if you want to enforce your trademark in the European Union, in Japan, in Australia, you're going to have a registration. You can try to enforce a trademark here in the US based on your common law rights of usage, but if you are selling product in France or Germany, you really need to consider getting a registration in those foreign countries. Now, there isn't like a blanket international registration.
That's what I was going to ask you. Yeah.
Yeah, there are ways to file to try to get protection in foreign countries that is a little more efficient, and it's called the Madrid Protocol. And you designate the countries that you want covered in. You can designate the EU as a single entity. I have a lot of clients who don't necessarily opt for that, but what they'll want to do is file in the EU, and that would be a European Union trademark, and you are covered in all European Union countries.
France,
including new members that could eventually be added. I don't know how Brexit is going to impact a UK filing at some point. I have no idea. At some point, clients might need to think about filing just in the UK. And if you are selling on Amazon in these other jurisdictions, you really should think about getting a registration in those particular jurisdictions where you're selling.
So is that something you can do? Can someone go to you and say, hey, Suzi, I want to file in Australia, European Union, and Russia, for example, and the US. Can you manage all that for them? And is that part of it?
Yeah, I do manage that on behalf of my clients just because sometimes it's easier for them.
Yeah.
I can't do a Russian filing. I can't do a European filing. So I have to get an attorney in that jurisdiction to do it.
Yeah.
But I do manage that on behalf of my clients if they want me to. Alternatively, if a client feels like they want to go directly to the EU and use an attorney there, they can go directly to that council and do it that way if they prefer.
Gotcha. So if someone's starting to sell in the US and then later they say, man, I want to start selling in Canada, and then a natural next place would be UK, they could add on or file for those trademarks sequentially later on if they want to. They could start in one country and then file here and so forth.
Yeah,
okay.
And that brings up a good point. After you file in the US, you have 6 months to file internationally and claim that benefit of the US filing date.
Oh, wow. Okay.
For a lot of jurisdictions. Now, there are some benefits for that because, like I've talked about, in foreign countries, it's the first to file. Right. But within that 6-month period, as long as you file, in the European Union, you can claim the benefit of your US filing date. Gotcha. It's sort of what I call a soft deadline. You can always, foreign file, but you might not get the benefit of your earlier US filing date.
Right. And the importance of earlier filing US date is simply it covers me starting at that period. Instead of now, let me just use an example. So I'm not going to mention the brand name publicly here, but as you know, fashion is a huge thing that my wife and I sell. And so for us, if we trademark that name going back when it started, 2012, 2013, then if it's approved, we're covered from then all the way to the present, not just the present future, right?
Right.
Okay, gotcha. That's super helpful. There's a question Steven asks. Steven, he says, what if you're going to have numerous variety of products in different categories? Is there a generic or broad category for trademarking? This question comes up every day. So what you're about to say, you have like every ear is like growing. So.
Yeah, this is an interesting situation. And I think that you kind of hinted at this with your own question at one point when you sent me that. So I could go in a few different directions with this. I do encourage people when they're selling in private, when they're doing private labeling to consider kind of sticking in the same category, pet product, or let's say pet travel, for example. If you did something like that, when you roll out new products within that category, you can likely keep the same trademark. It makes sense to call it all the same thing. Mm-hmm. Now, if you did pet travel, but then you're like, I'm going to roll out some garlic presses, that's whatever you picked, or some fidget spinners, whatever you picked out for your pet products, that trademark probably isn't going to work for your fidget spinners or your garlic presses. But you could, but you have to really consider the trademark itself and see if it made sense. And that's why I think it's really good when people are starting out, you know, kind of get into a category, like niche yourself. And then that would be a way to save on those trademarks is, you know, because when we file the trademark application, if you're in pet travel, you know, we would include, you know, doggy bowls, leashes, collars, those pads that you put down in the back of your car. We would include dog car seats, those little dog, I don't know, seat belts that they have. Like, so you would include all those different things. Now, when I file trademark applications, I try to be as broad with the goods description as the USPTO will permit me to be. Gotcha. At some point, they might be like, okay, you need to narrow down your goods. But if we can be as broad as possible when we define our goods, when we initially file the application, if we start rolling out new goods, then we can take a look back at our application and be like, okay, well, this looks like it fits in
covered
right. Covered as originally filed. Yeah. Now, that's not always the truth, and things change, you know, that's not always the case. Things change as your business grows, and sometimes someone will roll out a new product, will look back at the application or registration and realize, okay, well, this new product that you're rolling out doesn't necessarily fit the scope of your products, right? So we're going to have to file a new application. And that happens occasionally. We try to do things to keep that from happening, but it happens. Now, as you know, Steven asked, is there like an umbrella, like a category that you can cover everything? There's not really. You pick shoes, or you pick pillows. I'm using things that I see all the time, or mugs, or, you know, you have to pick those specific categories. Now, one thing you can consider doing, if you have your own kind of freestanding e-commerce website, mm-hmm. you can file, and I think it's class 35, you can file an online retail website including these goods. Okay, that's one way you can do it. And sometimes if I have a client that is specifically in e-commerce and selling under their own e-commerce website, then I can justify doing that. Now, if you're just importing microphones, I'm like looking at my microphone. If you're importing microphones, but you're not necessarily offering this e-commerce website selling microphones, we're going to probably need to file for microphones. And I know that's fairly specific. Yeah. But what I could do is I could try to get it for audio goods, including microphones or something like that. So there's different strategies that you can use, just really depending on what you're actually doing, whether or not you're offering this freestanding e-commerce site where you have a lot of different goods on it versus, well, you're just importing a product or two and you're selling it.
Gotcha. So class 35.
Class 35, yeah. You'd want to look at retail, online retail services.
So online retail, I'm going to remember that. So for example, let's say someone wanted to sell pet supplies, automotive parts, and kitchen supplies. Even though those are three very different categories, there's a possibility that if they have their own online retail website, they could use class 35 as an umbrella to cover those variety of products. Mm-hmm. Now, do they have to have all those products listed on the website before they get approved? Or because what if later they wanted to add on, you know, tea dispenser, you know, or something? I love how we pick up stuff from our desk. Or
I know, right? It's like you look for things around.
It's like the show of random stuff on your desk. But like, what if they wanted to add on different categories later? Do they have to have everything on the website first before they get approved? Or what is that like?
They don't necessarily, to get approved, they wouldn't necessarily have to show every single product that they listed. Okay, so like if you filed for online retail website featuring coffee presses, tea presses. Oh my gosh, I don't even want to show it's on my desk.
Should I show? Oh, okay, forget that, guys. You didn't see that.
On to the next question. No, I'm just kidding. You wouldn't have to show each of those products. Right. You'd probably have to show a few of them, like because the examining attorney wants to make sure that you're actually offering those particular services, you know, selling those particular goods. But if later on you added a new product line, you wouldn't necessarily have to file a new application, right? Because you have the services. But in some situations, I would recommend it, depending on how you're using it. Gotcha. So, I might recommend if you decided to start selling tennis shoes under this brand, I might be like, okay, so you have your online retail website here and you're selling garlic presses and tea presses under this brand name, but now you want to start importing tennis shoes. I would probably say let's file specifically for tennis shoes.
So that you have specific protection in case someone else tries to use the same brand, saying the same thing, say, look, I'm covered. So,
and one thing I want people to think about too is when you file with the USPTO, when you have your pending application, when you get your registration, when third parties come along and they're doing some of their own searching, just like I talked about a minute ago with that preliminary knockout quick and dirty search,
yep.
You want to increase the chances of your mark coming up in a search in an effort to kind of deter someone from using that mark. Now, of course, people could still look at it and be like, well, our trademark is different, so we're going to still file. But there are a lot of people and attorneys and brand protection companies that are constantly looking at the USPTO, and if they come across your mark and they see that there could be a conflict, that's going to deter them, and they're going to advise their client to avoid that mark. So yeah, you get to use the R in the circle once you get your registration, which is cool, but you also are on the USPTO database.
Yeah, which helps discourage them from even trying. Is it even worth it? I don't want to go to court over this. So
Exactly.
Yeah, so it sounds like, if this is a good summary of what of the whole trademark topic is, on what the beginning stages, I'm getting a trademark for my really cool pipes because I want to protect it. I don't want someone else using my brand. But later on, the value is once I'm really well known, there's now value to this brand. If I say Nike, how many people in the US don't know? Just do it. Or if you say Whirlpool, how many people don't think washer dryer? I mean, even the word Xerox, I used to work for them. I used to sell copier machines. We would say, go Xerox this. Talk about branding. Xerox is a weird, I think it's a stupid name actually, but actually if you think about it, they branded so well, it became or Kleenex. I did not know Kleenex was an actual brand name. I thought it really meant the little, those are called tissues. So it's like their brand became so popular, it dominated the original word, which is incredible. Like, talk about brand value. It's amazing. And that's super cool. There's a question here I want to address. So, oh man, we got a bunch. Okay. So Andrew says, Suzi, why does it take so long at times to get a trademark? What are things one can do to get it done promptly?
Hey, Andrew, that's an awesome question. Don't blame your trademark attorney on these things taking so long. First of all, it's not our fault. There is a backlog at the USPTO, 3 to 4 months for them to even pick up your application for examination. So that's not anything that we can help. So if I file an application for someone on May 1st, May, June, July, August, I know I'm not going to hear back from the USPTO till sometime in August. That's just their backlog. They've got a lot of trademark applications they have to go through. After an examining attorney eventually picks up that application, they're going to examine it based on a number of factors. They're going to look at procedural issues. They're going to look at reasons to refuse it on a substantive basis. And if you get an office action, which is where they reject your application based on procedural or substantive issues, that can take the application process even longer because, now you have an attorney, maybe you have your attorney who's working on this. They probably have a backlog of cases they're working on. It can take them a month or two to get to it. After you get that office action, you have 6 months to respond. So, a lot of times, your attorney or whoever's working on this for you can't get to it for a month or two. It, kind of extends it even longer. Let's say they file the response. It'll take another week or two after a response is filed for that examining attorney to look at the response.
Right.
And let's say that the examining attorney says, okay, everything looks good. Let's proceed with the application. The next step is that it's published for opposition. Right. And this is a 30-day period where third parties are given the opportunity to oppose your application. So that's another step in the process. That's another hurdle. Yeah. If you let's say that you get through the opposition period with no opposition filed against you, and you filed your application on an intent to use basis, at that point your mark is allowed. And that means that at some point within the next 3 years with extensions, you have to show use of the trademark. So I guess it's kind of a long-winded answer to your question, that there's just a lot of steps in the process, and several hurdles that have to be overcome before you can be granted a registration.
That makes total sense. And I'll add to that, Andrew. Look, one thing that's helped me a lot is when you're spending money or time on something for your business that's either going to protect your brand or help you to make money in the future, view it as an investment versus an expense. And there's sometimes a gray line between the difference. Yeah, it's an expense, both of time and money. But think about it this way. If it even took me 5 years to get a trademark approved, which it shouldn't, but if it did, it's still worth it to me if my heart and mind and goals are in this to build a business. Because you're not just selling stuff on Amazon, you're building a business. And I think that's one of the most important perspectives for people selling on Amazon is Amazon this year, and I keep hearing this over and over again, both from people who used to work at Amazon, people who do work at Amazon, is they're really focusing now on dealing with counterfeits, which I'm very excited about. And that's partly why the brand registry option is closed, and they're supposed to open it in May. There's rumors, Suzi, I don't know if you've heard anything on this, that it's going to be required to have your trademark now to get brand registered, but maybe that'll include brand gating as well, which obviously, we don't know for sure, but this is what I'm hearing. Like, this is the year they're going to really crack down on counterfeits because it's become such an issue. So in fact, this is such a big deal, Suzi, that in our training, we had a whole video on trademarking, and a lot of it I learned from you, I must admit, by watching interviews. And we had we moved it to the very beginning because it becomes such an important issue. Like, you're protecting you, your company, your value. It's perspective. Like, if I was building a brick and mortar business, I would have to go through so many applications. I have to set up with retail, the rent payments I have to do. If I'm going to sell any kind of liquor, I have to get an approval for that. If I'm going to sell food, if there's a grill, that's a big deal. My dog is howling. He's howling.
Bring it in.
Like, yeah, that's it. Say it. So anyways, we have another question. So Hazel said, Seth, Hazel here, as the site mentioned to check trademarks, is it just for the US or do they cover UK as well? So I'm assuming she's referring to NOAM, USPTO.gov, and I forget if there was one more you mentioned, but I'm assuming USPTO.gov is only for US, right?
Yeah, if you're interested, Hazel, in searching UK, you would need to look at their database or have an attorney do the searching there for you. Now, I will go back. The comprehensive trademark search that I mentioned a minute ago, which is sort of like that step above like a regular preliminary search, you can add on a worldwide searching option to that, which will search across, I guess, the globe. I don't really have anyone do that much, just because so few people are interested in filing internationally, especially at the outset.
Thank you. That's really helpful. There are more questions coming in. So just so I'm clear, the trademarks they're talking about are for the brand, not the specific products. And I'm going to add a piggyback question to that. So just to make sure I understand too. So I'm going to show you guys a new product. This thing actually is awesome. This is not my product. It's a computer stand. They call it the Rooster something. Rooster Nest, I forget. Anyways, this is amazing for laptops. So if I'm selling this, Suzi, and I'm selling my Oakwood pipes, this is for smoking tobacco or just looking like I'm cool. And this is for my laptop stand. I actually don't smoke anymore pipes, but I used to, and the smell of like fresh wood tobacco is such a great smell to me. Hopefully I didn't offend anyone, but I don't like to smell cigarettes, but pipes, it's just a whole different, Anyways, my grandfather used to do that.
Yeah.
But I'm selling both of these things. And this is a brand that's registered on Amazon, the name of it. And then this also, let's say Oakwood, and also say Rooster. Okay, so Rooster is a brand I registered. Oakwood is a brand I registered. If my trademark covers both of these types of things, and I know that's a big if, can I protect both with that trademark? Even though I have a different brand registered on Amazon, can the trademark be an umbrella, or does it need to be the same name as the brand that I got registered?
I would suggest it being the same brand that you got registered.
Okay.
So if I'm understanding your question correctly.
That way Amazon's like, oh, here it is. We see the file number. You're good.
Yes.
Okay.
One thing that's important about that is when it comes to enforcement of your brand on Amazon or your trademark, they will look at your registration number. They will definitely look at that. I mean, a lot of it, I think, does depend on who picks up your case. But if you file, you know, an infringement, they're going to look at your registration. And if they see that your registration doesn't match up with that product that you're selling, then they could, you know, refuse to enforce it. So I would suggest that it be consistent.
Okay. Now here's another question then. What if the name of the store is the trademark and I get to, and you may, I don't know if you know the answer to this now, I don't expect you to because you don't work at Amazon, but if the name of the, let's just say the name of the store is Oakwood, I've been selling pipes, and then along I come and I want to register a different brand, Rooster. If the store name is registered, okay, but the brand names are different, would that possibly protect the products or probably not? Probably not. Okay. A store name is just your store name. Of course, I work with a lot of people whose store name is the same as their brand name. But I also work with a lot of people, you know, a lot of sellers who have sort of their store name and they have multiple different brands under their store name. So, you know, an example of that would be, you know, Nike. We'll go back to Nike. You know, you have Nike, the company name, and Nike owns hundreds of trademarks, you know, including Nike, Just Do It, the swoosh. Yeah. And I'm sure there's additional word marks that they own that I'm just not thinking of or that I don't even know about, you know. And you also have to consider that trademarks are freely, they're licensable, which we could go into another entire presentation on licensing your brand. Yeah. And they're assignable or sellable. So a company like Nike might purchase another company and then they would own a ton of different brands that aren't really necessarily related to the all the brands that came with that. That was part of the purchase. Now they're the owner. Yeah. Okay, gotcha.
And one thing I want to say, I think that one really important thing that you mentioned I want to bring up is, you know, when you're selling on Amazon, I don't want people to get so hung up on Amazon. You know, like I think it's really important that people build not an Amazon business, but build a brand, because that's what's going to have long-lasting, you know, a long-lasting impact for years and years. We might not, you know, seller privileges might be removed in 5 years from Amazon. But if you've worked on building a brand, that is yours, you know, and you can use it on your own e-commerce site, in a brick and mortar, if we still have those around in 5 years.
Yeah. What is brick and mortar?
Do you know what I mean? So it's so important to focus on building your brand. Don't underestimate the importance of the value of a brand. Like think about Harley Davidson, for example. I wouldn't doubt it if their brand value is more than their product value, just the value of that brand. Totally. Now, are we all going to come out with a Harley Davidson label or level brand? Probably not. But why not use something like that to aspire to? You know, look at your favorite brands and what they're doing, and you know, I think it's important to emulate that. When you find a brand that you love, you know, obviously avoid PR nightmares like United, you know, things like that, because something like that can kill your brand. Yeah. And that's super important. And just remember too, that if you grow this brand over the next 5, 10, 15 years, Amazon might not be around any longer, but your brand can be, and it's around as long as you continue to use it. Yeah, that's such a good point. Yeah. Yeah, you can sell, you know, you might have 10,000 units of inventory in an Amazon warehouse, but you know, your brand value at some point could be way more than the value of what that inventory is. I mean, it just depends. And maybe at some point you want to sell that brand, you can do that.
Yep, absolutely.
The value of the brand is just as important, in my opinion. And maybe I'm biased, but it's just as important as the value of that tangible product.
Well, as an investor, I see that because I'll just give an example. Birkenstock sandals, they used to be on Amazon. They left Amazon because they were so tired of people selling knockoffs, which I found so interesting. Why did they do that? Because of the value of their brand. Mm-hmm. One of the fastest ways to build wealth, guys, is you build a company and you sell the company. That's a very fast way to become a multimillionaire. And if you sell the company and your brand value is not there, then what are you selling? You're just selling a system and processes and contact information, but not a brand where people, oh, I know that brand, I'm gonna go get that one. You know, kind of like Keurig. When you hear Keurig, you immediately think, most people do, you know, oh, the really fast coffee that tastes pretty decent. Never gonna be as good as the, you know, whole roast, but still, like, people think that. Keurig, that's what it means. Yeah. They have so much brand value, it's incredible. And they had to start one day where no one knew what Keurig meant, and they had to climb that hill, and it took so long, so many hours, and so much time and investment. I think for us who sell on Amazon, we idolize Amazon to a fault. Like really, like Amazon is just a platform. It's a great opportunity to get started, but we should not stop there. It is a 1-point failure system. They could suspend you with no reason at all legally. Like they could, okay, tell me if I'm overstating here. I'm talking to a lawyer here. So, but to my knowledge, they have the right to suspend you.
You have no recourse.
Yeah. Because you're pretty much saying, like, it's like going into a store. A store can refuse service. You know, it's their property. It's their thing. They can make you, they can just say, you're done. We don't like you. You know, that's a lot of power. I don't want to be so dependent on Amazon that they have that power. All right, one more question, Suzi, and thank you again for being here on this show and being a part of it. So I'm gonna, Isaac has a question. He says, Seth, can you ask her, what's the best way to contact and enforce your trademark? Do you have to contact them directly, or is there an authority to file the claim?
Okay, I'm assuming Isaac is talking about on the Amazon platform. Does he give clarification?
I believe in these chats, they're delayed, so we're probably not going to hear the response here. But let's take it that direction, because that's what most of these people are doing. Yeah.
Isaac, great question. And we'll assume that you're talking about the Amazon platform. If we're wrong, just let us know, and I'll revise my answer a little bit. But on the Amazon platform, you can contact the seller directly via kind of their online store. It says like contact the seller. You can send a cease and desist letter that way. Now, in terms of obtaining their contact information, I don't really know how to do that. You would have to actually get a subpoena with Amazon. I've never gotten to that far. Usually, if I'm trying to remove a seller because they're infringing my client's IP, I usually go directly to Amazon. And then a lot of people don't want to go directly to Amazon. They want to give the seller an opportunity to remove themselves. So that is your option, to give someone 48 hours or whatever, and your attorney might approach it a different way. But one thing that I've learned, number one, is that sellers are very rarely going to comply. Of course, I get some that do. Sometimes I get responses and they're not very nice. So, you know what I mean? Sometimes I'm like, I just don't even want to deal with that. I'll just go directly to Amazon to get them removed. And then also I'm aware of the fact that time is money. And as long as a seller has someone infringing their rights or is counterfeiting their product and they're stealing the buy box, and literally I look at it as theft. I mean, they're stealing the buy box from a client. Time is money, and so I want to get them removed as quickly as possible. So I typically go directly to Amazon. There is a form for reporting infringements. And Seth, maybe
it's the infringement claim. I just posted it. Yeah.
Okay, perfect. Yeah, that's usually where I report, just like anyone else. That's where I report problems, and that seems to be the quickest way for Amazon to respond. Now, I do understand that sometimes Amazon responds with like crazy canned responses. I'll even get these situations where it's like it'll be like a canned response from Amazon that says, you know, we need this information. I'm like, I mean, I've been doing this for a while. Like I already addressed every single one of these issues in the initial email, but you know, just kind of roll your eyes and give Amazon what they want again. And you know, sometimes you have to be persistent. I can usually get third-party sellers removed from Amazon, like if they're infringing my client. And I do think that in some situations it helps because I do send it from a law firm. Yeah, so I hope that answered Isaac's question.
Super helpful. Yeah, and I just posted the infringement claim. I know some people have been very successful just by when they post it. There's an option to include your trademark number, and so they just include that, and you get very, very fast reaction. One thing I've noticed just in the last few months, Amazon's treating trademarks much more seriously than in the past. It's less of this kind of loosey-goose, well, yeah, okay, it looks like you're good, okay, do it. Now it's like, oh, they have the number. It seems to be much more fast and fierce, which I'm excited about because I think there's a lot going on the inside that we're going to see in May. So, okay, cool, awesome. Hey, thank you so much, Suzi, for being here. Do you have any last words that, you know, there's a bunch of Amazon sellers here watching right now and many more who are going to watch this later. If you were to give, you know, one piece of encouragement or advice to people here, what would you say if you just had any final words?
it's a lot less expensive to be proactive than reactive. If you get a cease and desist letter from someone, I'm going to another piece of advice. I'm going to do two. If you do get a cease and desist letter from someone, don't ignore it. Make sure you talk to an attorney. If you do get a cease and desist letter, make sure that you double check what those claims are based on. Particularly if it's a patent claim, make sure they give you the patent infringement or the patent, I guess, application or pending. Patent pending number or registration number, so you can cross-check it, make sure that their claims are valid. When you're dealing with patents, it's probably a really good idea to get a patent attorney to look at those claims to make sure that they definitely have a valid basis to send you an enforcement letter.
Awesome. Hey, thank you so much, Suzi. Thank you for being here. Great answers and super helpful. Hey, everyone, just want you to know that Suzi and I, right after this, we're recording a full-on private conversation, more like a presentation, where she's going to go through some of her best content, and we're going to record that, and we're going to include it for all Just One Dime members. So you're going to get a full-on session with a PowerPoint slideshow of this and a lot more, just explaining answers to these kinds of questions, so you guys have a foundation. And so for anyone who's a part of Just One Dime, you get access to that. If you're not a part of Just One Dime, I encourage you to sign up. We have 8 coaches. We have full-time staff. We have over 70 exclusive videos that you won't find here. We have over 3,000 reviewers from 4 different countries who can help with that in a legitimate, non-breaking TOS way. There's a ton. And it continues to grow. And now we have Suzi Hixon as part of that. It'll be pre-recorded, so it's not like a live interview. You can just call her up. Hey, Suzi, I have a question. So people do that with me to like, do you think that how much time do I have in the day? Like I got a wife, I got kids, I got a howling dog. Actually, I think he needs to go use the restroom. So he's like, please, Dad.
Bring him in for the webinar.
Exactly. Yep. So yeah, thank you so much, Suzi. And very awesome.
It was fun.
All right, guys. Have an awesome day. Keep it real. Talk to you soon.